Mr. Levin, I appreciate you taking the time. Thank you.
Good to be with you.
My first question will be a broad one, and it'll partially quote from the titles of one of your recent articles. Why does a strong, united America require effective criminal justice policy?
Yes, well, that's a great and very timely question. The Basically, you can easily see the connection between trusting the police, trusting the justice system, and trusting, the government writ large. Now, of course, a healthy skepticism of all those is definitely warranted. I think the problem comes when, of course, the distrust becomes so great that in the context of policing, for example, people don't report crimes to the police, they don't cooperate as witnesses, and of course, in the context of democracy, opting out can mean not voting. And I was kind of fascinated to see some academic research recently that demonstrated that people who actually have been repeatedly pulled over, wrongfully by mistake, and had those negative interactions with police are actually less likely to vote, adjusting for all other factors. So there is this thread that ties together these issues of distrust and issues of kind of legitimacy of our system being challenged. And so I think that what's interesting really is you have this on the far end of both sides of the political spectrum. Of course, you have folks on the right who are very skeptical of want to get rid of the Department of Justice, and folks on the left who want to abolish the police. So whether we're talking about the FBI or the police, there are real problems that we shouldn't whitewash. But I think we also have to recognize that there's a reason, like based on Thomas Hobbes, the main reason that human beings come together to form governments is to protect their lives and liberties, and that there is this essential role for government when one person's actions infringe on the rights and liberties, and of course, in some cases, with murder, the lives of other people. And we have to have government with enough legitimacy to step into that breach and ensure that we have hopefully a society that's both has reasonable levels of safety and reasonable levels of liberty. It's a delicate balance, but there's no doubt that there's a role for government in that.
Balance is so important in the law, right? So many legal principles, legal doctrines, rules of law turn on balance. And this country was founded, right, under the idea that we balance the government's ability to maintain order and the people's ability to maintain their rights. And that's been a tough balance to strike over the decades and centuries. Where are we now as a country in terms of being able to do that?
Yes, well, it's a great question. And I think, we have a lot of advantages in terms of course, the Constitution, the Bill of Rights. I mean, obviously, one of the founding aspects of this country was the idea that we should be governed by the rule of law, not the rule of man, and particularly not of a monarchy. And, it's certainly the idea that we all have to live under the same laws was very important to our nation's founders. And so basically, regardless of your race, your station in life, your connections or not having connections, theoretically at least, everyone should be subject to the same laws and should be able to avail themselves of the justice system when they feel someone else has violated their rights. So I think that we're still in a good place relative to much of the world on this. Certainly, there's places across the world where people are routinely, locked up without a trial. Although I did just read about a case in the U.S. where somebody's been in jail for 11 years without a trial, which was astonishing and deeply disturbing. But that is very much the exception, of course, in the U.S. that we have this constitutional right to trial, even though, over 95% of cases are resolved by plea bargains, which is an issue that we need to address in many ways to make that system more transparent. But I think we're actually, when you even compare us to other developed countries, we're pretty strong on the due process side, on the ability of defendants to, challenge the government. But where we're really, I think, certainly well behind countries like Germany and Europe, where I recently visited the prisons, is on the correctional side. In that, if you look at what's going on in our jails and prisons, the number of people who are dying, young people is really shocking, and obviously the conditions in many instances are inhumane and certainly don't lend themselves to rehabilitation. So the good news is we are seeing states like South Carolina and North Dakota, they've taken steps to change how they're doing incarceration. There's certainly work left to be done, but they're taking lessons from some of the European countries on that. So I think it is always helpful to kind of look at how other countries do things and identify areas where they can learn from us and we can learn from them. I think that but overall, I would say that we definitely have work to do. If you look at kind of the levels of trust in terms of, do most Americans think that everybody's going to be treated equally in the justice system? I think that there's a lot of skepticism there, and rightfully so. I mean, in terms of, we know people that are African American are subject to disparities. People that are low income can't afford, in many instances, a capable attorney, so they're at a disadvantage. And of course, then you could look at people who are disabled, people that are don't speak English, and they're really up against it in different ways throughout the justice system. So I think at the end of the day, what we need to do is make sure we tailor the way people are treated into the justice system based on the vulnerabilities, the challenges they have as they come into the system, and then rather than try to fit a square peg into a round hole and just say, okay, well, somehow we've because that it's fair if everybody's simply treated the same. Of course, if you've got somebody who's deaf and can't hear the court proceedings or can't hear the police officer's command, yeah, they treated the same as everyone else, but no one would say that's fair. So that's why the justice system kind of has to adapt to individually tailor itself to the differences of people coming in terms of what their needs are, what their, in some instances, their vulnerabilities and limitations are.
You mentioned trust. Trust is so important. I feel like so many people have an issue with trust because of something called prosecutorial discretion. It's a term that in our criminal justice system is likely the most important term. Should we do anything about prosecutorial discretion in terms of more oversight, in terms of more checks and balances? Is that a possibility even?
Yeah, that's a great question. I think we do need some level of prosecutorial discretion, and part of the reason for that is, of course, we have this massive number of criminal laws. The General Accounting Office identified 3,500 federal statutory offenses, and then there's thousands, perhaps hundreds of thousands of more regulatory offenses. Then similarly, states like Texas and Arizona, we've counted a couple thousand criminal offenses on the books. So and of course, prosecutors have very limited resources in terms of how many prosecutors they have. Obviously, there's a limited number of courts and judges and so forth. And most people that are prosecuted need a lawyer funded by taxpayers. So that's part of the capacity constraints as well. So when you try to put too many cases into a system that really can only handle a certain number of cases, if we're going to do it, by the book in terms of providing a due process, that's a real problem. So prosecutors, have an important role to play and as gatekeepers to not just, bring every possible case, but only bring those cases that really advance, obviously, the core aims of the system in terms of, holding people accountable for conduct that's harmed others, protecting public safety, deterring others from harmful conduct. So that's, I think that we've obviously seen a lot of controversies in the last few years in terms of this issue of some prosecutors that are referred to sometimes as progressive prosecutors. I don't think it should be an ideological. I think it ought to be, are you effective in accomplishing those aims I mentioned? But some said they would typically, if you read the fine print, presumptively not prosecute certain offenses. And, they were elected on that promise. I think in some instances they scaled back in terms of what types of offenses they were talking about. And they, in some instances, certainly did a better job of clarifying than maybe they had earlier that, yes, we're going to look at every single case that a police officer sends over, which they absolutely should do, because there can be a lot of differences in terms of what are someone's prior offenses, what are the other circumstances surrounding the offense at issue. But overall, I think there is a role to say for prosecutors, whether it's, for example, we know small amounts of marijuana. We actually have data that even in here in Texas, in major cities, most juries are not going to, and increasingly in suburban areas too, most juries are not going to convict someone for possessing, one marijuana cigarette or something. So, it would be a fruitless endeavor. A prosecutor, once that's kind of realized, most defense lawyers are going to tell their client not to plead to it. So, and then there's the whole issue of all the violent crimes and serious matters they need to put their resources into. So, and we've seen some distinctions. For example, in Dallas, the DA said, well, yes, I'm going to continue presumptively prosecuting trespassing on private property if somebody's, just sets up shop on your lawn or something. But in terms of a homeless person sleeping in a light rail station, which is, one of the issues, no, I don't think giving them a criminal record is the solution. I think they need to get services. So, that's kind of where the rubber meets the road. And, we do have to realize prosecutors typically don't have a budget to pull from to get somebody into treatment. So they've got to depend on the other systems stepping up to the plate, where in those cases where, really jail and giving someone a criminal record aren't the answers.
The counter argument to that is the adversarial system of justice, right? Prosecutorial discretion virtually in an unlimited way is fine, because we have a system in which defense lawyers are put in place, and it's their job to ensure that prosecutors are held to account. What do you say to that?
Well, absolutely. And that's one of the reasons it's important to get back to doing more trials, because, for example, if there's police misconduct, if evidence was hidden or mischaracterized, or there were problems in the forensics labs, which we've seen from Boston to Texas, but those things really often only come out in the discovery process and even at the trial itself. So the system does need to be stress tested, and defense lawyers have a huge role in that. One of the concepts I'm really fond of is that there's quite a bit of evidence for is holistic defense, participatory defense. There's an example, the Bronx Defenders in New York, but basically they do have not just themselves as attorneys, but they partner with social service providers. And this is really important because the timeline of the criminal justice system in terms of how long it takes to process a case does not match up with often what someone's needs are in terms of mental health treatment. If they just had a breakdown, in terms of obviously treatment for opioids, in terms of getting stable housing and employment. So the Bronx Defenders approach, this holistic approach, they address all those issues while, as soon as possible, right when the case comes in the door. And then it turns out when, they're sitting down with the prosecutor, which sometimes is, 6 months later to talk about a plea, the prosecutor goes, well, you know what? It looks like you've already gone a long way in solving this person's underlying problems that got them into the justice system. And especially if it's a nonviolent offense, maybe we don't need to give them a lifetime scarlet letter of a conviction. We certainly don't need to send them to jail if they've been doing well on a pretrial services program. So I think, a lot of the challenge that we have is to try to front load the resources in the system so that we can get people into a better place before their case is actually adjudicated, and then determine whether it really does need to be adjudicated at all. And so defense lawyers have a big role in that, but I think when they can partner with others, that's the ideal approach in a lot of cases.
I'd like to talk to you a bit about pretrial detention and bail reform. Now, it seems that the bail stage in a criminal case has two problems, really. Number one, it seems inherently un-American to tie somebody's freedom to money. There's just something that doesn't sit well with folks about that. But more importantly, perhaps, there's a due process concern, right? That folks are being punished effectively prior to being adjudicated as having committed any crime or done anything wrong. What is your position on pretrial detention and the effectiveness of bail in ensuring a defendant returns to court?
Well, yeah, that's a great point. And it goes back to what I said earlier about, if you just treat everyone the same, which is kind of an equality approach, but not looking at equity, in the example of obviously somebody who's deaf, having the police or a judge verbally tell them this or that, it doesn't have the same effect. So it's not sufficient. And likewise, if you look at bail schedules, just having the same amount, which is what bail schedules are, the same amount everyone has to pay to obtain release prior to trial. Well, obviously for someone who's wealthy and someone who's poor, that has a very different impact. And the person who's poor ends up being kept in jail. And so it's not fair. And we need a system that's based on, public safety, on risk, not on how much money someone has. And of course, a lot of states like New Jersey have moved with very positive results in this direction. And, the really part of what New Jersey did was to, they basically, virtually there's no more use of money bail there, although they didn't outright ban it. They set a very high bar. And essentially, it's interesting. There's just been a handful of cases since that those reforms were passed a few years ago in which money bail has been used. It's something like 10 cases or something, which really demonstrated that what it was being used for before was to just keep people in jail. And instead, of course, the New Jersey reform said under certain conditions, judges could deny bail and say someone, based on their objective assessment, is so dangerous that no possible conditions accompanying their release could reasonably ensure public safety. So, and then a key part of it is they actually funded the pretrial services, court reminders so people get texts to remind them to come to court. So I think what one of the things we do need to do is first, say yes, after extensive due process and immediate appeal, making sure someone has good counsel, that they, especially obviously in the serious cases, you have a serial killer or something, we all, I think, would acknowledge there's serious cases where somebody does need to, and we actually have examples where someone says they're going to commit another serious crime if they're released. So there are those small number of cases where someone, the appropriate thing is for the court to just deny release altogether, which is referred to as preventive detention. And then in all other cases, basically the decision has been made that this person's not going to be preventively detained, then their release should not be conditioned on putting up a certain amount of money. Now, if the courts can say, okay, we've determined that you're going to be released, here are the conditions, and they have to be conditions that are attainable, that the person can meet. And certainly there are examples of where people sign something which is a non-secure bond saying that if I don't return to court, then I'm going to agree that the government can take title to my car or whatever. And then of course you have examples of German jurisdictions do collateral, where someone's jewelry or something is kept with the county and they get it back when they show up. But this is all very different than commercial bail bonding, because of course in commercial bail bonding you're out that 10%, which can be a lot of money. If you have $100,000 bond, the $10,000, even if you do everything you're supposed to in terms of showing up to court, that's profit for the bail bondsman. And it's essentially a requirement that people buy insurance. But what's interesting is the bail bondsmen do very little to actually get people back into court. If you look at most of the cases where somebody's on the lam, they're actually found by law enforcement officers. The whole bounty hunter thing is really an illusion. I think the reality is, what we know is that if just by virtue of someone paying money doesn't make it any more likely or less likely that they're going to commit a new offense while they're on pretrial release, which is really where the public's concern is. And so there are things, though, we can do to reduce that likelihood, like connecting them to treatment. And certainly, there's a role for pretrial, for reporting to a pretrial services officer. Obviously there's conditions like someone shouldn't leave the county without permission, or if somebody is an alcoholic and that led to their crime, they're not supposed to drink alcohol. So there's conditions that the court and pretrial services agencies can enforce. You obviously don't want to over supervise people. If somebody's got a stable job, you don't want them to have to come to some pretrial services offices every week to have to skip work to do that when they're a low risk individual. So we have these objective assessments, these actuarial instruments, which New Jersey and other jurisdictions use, where we can match the level of supervision and conditions to the person's risks and needs. And that's really, I think, how we should approach it.
You mentioned earlier, why do prisons have such a hard time rehabilitating folks?
Well, I think that certainly in many instances, the conditions are not ideal, to say the least, for that. I think that here in Texas, of course, we're having, and Florida right now, Mississippi, Louisiana, the level of heat in our prisons, we're having a number of heat-related deaths and illnesses. Of course, crowding is another issue in many places, that the space that's theoretically supposed to be used for programming is used for day beds when there's overcrowding. Another issue is when you have a shortage of staff, which we do now in so many states across the country, then prisons are on lockdown a higher share of the time. In other words, that because there's not enough staff to provide adequate security for people in prison to be out of their cell, including going through programs, they just say, well, everybody's got to stay in their cell. And so these programs that may kind of look good on paper, their implementation, is spotty. And so I think that's part of the problem as well. And then reentry is a huge challenge. In other words, even if somebody does make headway in a program while they're incarcerated, if they get back right into the same milieu of people, places, and things that got them into trouble to begin with when they're released, then there's a higher likelihood they're going to be returning to crime. So, it's very important to kind of have a continuity. And one of the things we really going with, I was working with folks on the First Step Act in Congress and administration at the time, one of the goals we set was to have an individualized reentry plan. And shortly after someone's incarcerated, it could be within the first 30 days, this plan is developed that's going to basically say, here are the programs this person can benefit from while they're in prison, and here's how that's going to be kind of leveraged upon their release. Here's who the people are that they need to stay in touch with while they're in prison, in terms of family, ministers, and so forth, that could be a source of support when they're discharged. And so the visitation is a piece of that. And there's a plan for them on, for example, a skill they can learn in prison that then would translate into a job available in the workforce in the place they're going to be released. So this is really, and one of the things I drew in Germany that was very interesting is not only do they have, a phenomenal array of programs while people are in prison, but both in Germany and Norway, the probation officer, they're released onto probation from prison in almost all cases. The probation officer comes into prison within 6 months before they're released and starts working with them to arrange employment, arrange housing, and they actually take them on errands outside the prison, unless they're in a security classification that precludes that. They take them on errands to start lining things up. So it's a completely different focus, but it's one that, frankly, inside the prisons, people have a lot more autonomy. They make their own meals. They go to their job themselves, which could be in a factory building bumpers in Germany, right? There's all this degree of freedom in the prison itself, but there's also this and a tremendous concern about reentry and what's going to happen when they're released. And so the prison system takes on some, quote, additional risk by allowing these folks to do certain things in prison that are correlate with what might have to do when you live in the real world. So they take on that risk. Whereas in the US, largely, we say, we're just going to, try to focus the system on what's convenient for the prisons, which is to, in some instances, just let people sit in their cell and do nothing, rather than focusing on what's the interest of the public, which is that the person come out in hopefully in a better condition than when they came in, and that we take certain steps to reacclimate them to society, as their prison sentence is concluding.
Is the prison industrial complex, as it's called, responsible for some of this to a degree?
Well, I think that, it's hard to really assess that. I would say that there is a lot of, the most of the attention in most systems in the US is on, correctional security. And so it's on, cameras, lock and key mechanisms and all of that. And that's all valid. But what I was really struck by in New Norway was the concept of dynamic security. And that gets into basically the interactions in many instances between the correctional officers and the staff. And you go through 2 years of training to be a correctional officer in Norway. You learn psychology, you know, how to de-escalate and things like that. And in the US, in some systems, you can get into prison as an 18-year-old prison guard with just, you know, 3 or 4 weeks of training. And, you know, their job is framed as just make sure the person doesn't escape, right? And rather than also including this kind of therapeutic component. And I mean, treating people obviously with dignity is really important. And that can create an atmosphere where basically, you know, people in prison are a lot less likely to resort to violence if they feel like, yes, I'm not glad that I'm here, but I'm being treated like a human being. And if I have concerns, there's a grievance process that I can use and that be taken seriously. So I really think this idea really gets to this issue of procedural justice, which we also see in the policing field, right? If a police officer pulls you over, you're not going to be happy about probably what comes out of that, even if it's just getting a ticket, right? But the officer should tell you why he pulled you over. It ought to be, you know, courteous, and we ought to give people a chance to express their own voice, and hopefully feel like that the system is legitimate, that they're being heard, they're being treated fairly, even if they don't end up liking the result. So a lot of this does get back to how do we create an atmosphere inside our prisons and jails that is not adversarial between the correctional officers and those that they're supervising, but instead one in which, you know, there's a level of trust, and that there's I mean, I saw in Norway some of the activity officers, both them and the people incarcerated, are wearing street clothes, right? They're playing soccer together. It's a completely different, and no one's worried about being attacked, right? So, you know, when we think about the reason why most people in our society as a whole, most people don't commit crimes, is partly kind of a social pressure that they feel some type of attachment to their neighborhood, their neighbors, their neighborhood, their community, and they don't want to mess things up. And so if you can create, as much as possible, this sense of that we're all on the same team, even behind bars, that's going to make a huge difference. And that's the dynamic security that, you know, ends up, you know, enabling you not just to depend on, you know, things like bars, handcuffs, fences, and all of that as your only means of security.
Why is solitary confinement a bad idea?
Well, overall, like, that the definition is important to consider. You know, I think that it's essentially the standard Mandela rules would be 22 hours or more of being in a cell, you know. And so, for example, in the federal system, there's, you know, in many instances, 2 people are under, quote, solitary confinement. They're in their cell for 23 hours a day in some federal prisons, for example. So, but that's still solitary confinement, even though there's another person there. So I think but what we find is there can be an instance, certainly, where somebody who's in prison commits a heinous act against a correctional officer or against someone else who's incarcerated, and that they need a timeout. And so, you know, having someone, the other aspect of the definition is for a certain number of days, for 14 days or more, for example. So having somebody be kind of put into this, whether you call it solitary confinement or administrative segregation, this type of a different housing for a short period to address a serious issue like that, that's something that you know, has a role. But we have people that have been in solitary confinement for years in the United States, and we know from the research the effect on both their mental and physical health is very deleterious. And you know, just the lack of natural light, for example, affects our body in many ways. And obviously the lack of human stimulation of any type of conversation with another person is very damaging. And so there's a great deal of research showing the health repercussions of extended solitary confinement. And so, and then the other thing we identified was this. Fortunately, most correction systems have moved away from this, but there are examples of people released directly to the public from solitary confinement, and unsurprisingly, there was some research on a supermax prison, which is essentially a prison that is all solitary confinement. And they found, of course, that those who were released directly to the street from solitary confinement had a much higher rate of particularly violent recidivism, even after adjusting for all other factors. And that those who had been stepped down for at least a period, in other words, they were no longer in solitary in the several months leading up to their release, their numbers were more similar to those who had never been in solitary in terms of recidivism. So it comes back to what I said before, that the system too often kind of says this is what's convenient for those running the prison without regard to what's in the public interest after incarceration.
You've spoken in the past about the future of the criminal justice system. What does it look like?
Well, that's a great question. And I think that we obviously don't have a crystal ball, but I think the good news is over the last few decades, there have been a lot of advances that have had real benefits. And so I mentioned earlier, objective actuarial risk and needs assessments that provide, whether it's a parole board or a judge, with something other than kind of their gut feeling to go on in making decisions. I don't think anybody has suggested that those should replace the role of humans, but certainly to inform decisions. So that's an example. And of course, we've had new techniques come into play. We have drug and other problem-solving courts, mental health courts, veterans courts that have moved the needle. That, we didn't have veterans courts when people came back from Vietnam. We still don't have enough. But that's an example of an advance that we've seen. And then, the monitoring technologies is much more of a mixed bag. I think that there can be a role for some of them, and obviously, we have examples of, I talked earlier about the text messaging, reminding people of their hearing and also giving them directions on how to get there, and apps. I mean, now you have apps that people can use that, for example, they can reschedule their court date because they're sick or their child's sick. Whereas before they might've had to file some piece of paper, and in many instances, didn't have an attorney, so they just didn't do it. And they ended up getting a failure to appear and a warrant for their arrest. So apps to interact with the court system, to interact with, or online. Judge Scott Schlegel is a great pioneer in this area in Louisiana with his online programs. But basically, it gives the way for people to interact, and also with their probation officer. And this really took off during the pandemic, that people could use the app or Zoom meetings and things to basically have to check-ins and have be able to have notifications going both ways that would have otherwise been very cumbersome or wouldn't have occurred at all. And of course, we found that the rate of people missing hearings and missing appointments with their probation officers was much lower with Zoom than in person, partly because you didn't have transportation, childcare, other challenges. So I think most systems that I've seen have kept some level of this. Obviously, there's cases where, particularly with high risk individuals, there's a real need for in-person interaction and using things like motivational interviewing that are going to work better in person than through an app or the computer. So that's one. So we have all these areas where technology has really helped move us forward. I think, looking into the future, there are certainly concerns too. Obviously, with AI, for example, and some of the other developments we've seen. I mean, there was a study with folks who have ALS that couldn't speak, and now if they got something, basically they're in some device that surrounds their brain, they're able to, a computer is able to respond to their stimuli, what they wanted to do without having to, because they don't have the mobility of their arms either, but they're able to just basically the device they're attached to is interpreting their thoughts and telling the computer to do this or that. And so one could imagine eventually that it's quite possible that if people are having, evil thoughts about committing a crime, maybe that's going to be detected in some way. And are they going to be subject to consequences for that? I'd say no, because, right, I mean, we have people can say and think a lot of different things, and they have a right to do that. But when you actually, obviously commit an action, that's where the criminal justice system comes in. So, but I do think there are certainly legitimate privacy concerns that people have. I think there's important distinctions. Like, for example, if you're on pretrial services supervision, the government still needs a warrant to search your home. Whereas if you're on probation, because you've already been convicted, you give up that protection. So we have to keep those types of guardrails in mind. And I think that, it's a bit tricky because in some instances, when somebody commits, for example, a really low level misdemeanor, if they end up being assessed, it's actually found they have, more serious challenges that could benefit from a treatment program or whatnot. But we have to be careful, because if you've got something that's a Class C misdemeanor that someone couldn't even be jailed for, that doesn't really justify kind of the system sinking their teeth into that person and saying you've got to go to some, residential program for 6 months. So a lot of times there's this real mismatch between the offense that's committed and what we might think the person needs in terms of level of services. So that's going to continue to be a challenge, I think. But if it is truly a beneficial and therapeutic program, even if they haven't done something that gives the system kind of the leverage to force them into it, if it's really I think in many cases someone might say, okay, I'll do that even though maybe I don't have to, because I think it'll help me. So we have to kind of make sure that we're kind of taking advantage of opportunities to help people get on track, but we're also keeping in mind the proportionality of the system, and also the fact that even though people do give up some liberties based on the offense they commit, that it's got to be there's got to be some limitations around that are relevant to both what the potential punishment is for the offense, as well as what their needs are. So I think we're going to continue to have to sort that out. But overall, I'm pretty optimistic that technology is provided that we use it in the right way and in the right circumstances, can really help us achieve better outcomes.
Well, Mr. Levin, I appreciate your time. Thank you so much. Very much appreciate it once again.
Oh, thank you.